Let's look at the legal environment around information security. There are a number of different laws in which we operate. We have constitutional law, such as the Fourth Amendment, statutory law, Grand-Leach-Bliley, for instance, regulatory administrative law, like the Federal Trade Commission laws, common law, case law, and precedent. As cases are adjudicated in the court system, it establishes case law or precedent by which future decisions will be made. Within statutory law, the laws can further be divided into their association with individuals, groups, and the state. Civil law, for instance, are laws that pertain to things like contract law, employment law, family law, tort law. When you're talking about suing someone, you're operating within the confines of civil law. Criminal law are those laws which designate a specific set of criteria under which a crime is defined and the associated punishments that can be doled out as a result of an individual committing those crimes. We have quite a list here of laws that pertain to information security, privacy, and other topics. Some are very specific to certain industries, some are more general and apply across the board. Just a few of these that might be kind of interesting to look at. We'll look at a number of these, but you'll want to look at all of these in their context later to determine which apply in your organization and which don't. So, for instance, the Federal Trade Commission Act, you see this was 1914, but yet many of the rules inside the FTCA still apply today. Freedom of Information Act, FCRA, or the Fair Credit Reporting Act, for the protection of credit information, protection of privacy, the FERPA, protection of students' rights and information about students, copyright protection, cryptography protection, access to stored communications, threats to computers. So Computer Fraud and Abuse Act we'll look at in a little more depth. This is 18 U.S.C. 1030. It's usually referred to as either 18 U.S.C. 1030 or just a 1030 rule. Federal Agency Information Security, or the Computer Security Act, the trap and trace restrictions, criminal intent under the National Information Infrastructure Protection Act. Let's see, this, which is an update to 18 U.S.C. 1030. Trade secrets under the Economic Espionage Act, personal health information under HIPAA, the Health Insurance Portability and Accountability Act, encryption and digital signatures under Security and Freedom through Encryption Act. Let's look at some of these others. Copy protection under the Digital Millennium Copyright Act, DMCA. Identity theft, child protection under COPA, the Children's Online Privacy Protection, banking under Gramm-Leach-Bliley Act, accountability under Sarbanes-Oxley, General InfoSec under the Federal Information Security Management Act, or FISMA, spam under the CAN-SPAM Act, fraud across devices with 18 U.S.C. 1029, terrorism and extreme drug trafficking, U.S. Patriot Act covered that, privacy of PHI under the American Recovery and Reinvestment Act, which also included high tech, and we'll look at that, privacy of PHI, and here's high tech, and defense information protection under ITAR, and National Cyber Infrastructure Protection under the National Cybersecurity Information Act. And here's another one, terrorist tracking under the USA Freedom Act. One of the interesting things to look at, let me go back up on this list though. one of the interesting things to look at, and what's kind of a characteristic that you see of many of these laws. Let's go down the list a little bit. Well, if I go back to this first one, for instance, well, we could go here. You notice that many of the laws were written before 2000, 20 years ago. So you can see that the laws were written in the context of computing and using computers and the information that's either protected by the computers or that a company collects and stores through the use of the computers. But many of these laws were written many years ago in the context of the computing environment. The internet as a business proposition didn't really come into effect until roughly this time, 1993 to 1996, somewhere in that time frame. So as laws were written after that, of course, they incorporated the fact that the internet was part of the paradigm under which companies were operating. So one of the more important laws is the Computer Fraud and Abuse Act. It was written in 1986 and still very relevant today. This is 18 U.S.C. 1030. This is one that you'll see pretty much any crime that either the Secret Service or the FBI or any of the federal law enforcement agencies prosecute will more than likely include a 1030 adjunct into the prosecution. It's very broad. It has a number of different provisions, but punishments include fines and imprisonment for up to 20 years. And it depends on really the value of the information that was obtained and whether the offense is judged to have been committed for either commercial advantage, private financial gain, or in furtherance of a criminal act. CFA was further modified by the USA Patriot Act in 2001. And I don't know who thinks of these acronyms, but this is great. Uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism act. U.S. Patriot. And this was introduced, as many of you know, right after the 9/11 attacks in New York on the World Trade Center. The U.S. Patriot Act of 2001 was updated and extended in 2005, but in 2015, the United States Senate failed to extend the Patriot Act, and this resulted in the expiration of many of its components on June 1st of 2015. Around this period of time, you may remember there was some controversy over a section that allowed the National Security Agency to collect metadata. Not phone conversations, but data about phone conversations, such as the phone number, the duration, etc., location of the calls, etc. This resulted in a modification and incorporation of those components into the USA Freedom Act, which we'll touch on just very briefly. The Computer Security Act, CSA of 1987, was one of the first attempts to protect federal computer systems. It established a Computer Security and Privacy Advisory Board within the Department of Commerce, and you'll still see the Department of Commerce involved in many of the discernments on breaches in this country. But another provision of the CSA was the mandatory periodic training in computer security awareness. And this today we still see in your programs where you'll develop an annual computer awareness training. But I always advise, don't just make it an annual event. Make it something that you can do on a regular basis. Certainly quarterly, more often is even more preferable. The CSA charged the National Bureau of Standards, which is now the National Institute of Standards and Technology, or NIST, and the National Security Agency with the development of standards and guidelines, uniform standards and guidelines for most federal computer systems, technical advice, guidelines for use by operators of federal computer systems, and validations of procedures for and evaluation of the effectiveness of the standards and guidelines that are implemented on federal systems. Now, the beauty of NIST is you can go to the NIST site, nist.gov, and there are a plethora of policies and practices that you can use in your own environment to help write policies, to help write standards that you may use within your organization to protect your systems, your data, and to help educate your employees. I've used the NIST standards for years, and literally for years, even long before the internet was available. And there's just about everything you can imagine from a technical perspective, as well as a security and education perspective out there in the NIST writings. For privacy laws, many organizations collect, trade, and sell personal information. It's a commodity today, but it's a commodity that has to be very well protected. You provide information to your doctor, which becomes protected health information. You provide banking information to your banks. When you get a car loan, you supply all of that information to be able to get your car loans. So today, it's that aggregation of all of that information that pretty much defines an organization and defines the individuals that are represented by that data. And there's a tremendous amount out there. It makes it a commodity that attackers really want to get a hold of. So you need to be able to protect that data. And privacy, this last statement is absolutely correct. Privacy in this context is not an absolute freedom from observation. Rather, it's a state of being free from unsanctioned intrusion. The Federal Privacy Act of 1974 regulates the government's use of private information. And it was actually created to ensure that the government agencies protected the privacy of individuals and businesses' information. Now, this is not like a federal law of privacy. It's just requiring the government to protect the information that they might hold. The Electronic Communications Privacy Act of '86, a number of statutes. You'll see in there things like interception of wire and electronic and oral communications, or sometimes called the Wiretapping Act. But it applies to things like email as well as actual wiretapping. When used in cooperation with the Fourth Amendment, it prohibits search and seizure without warrants. And so these two work often hand in glove. The Health Insurance Portability and Accountability Act of HIPAA, defined in 1996, protects the confidentiality and security of healthcare data that is collected by a healthcare organization, a hospital, your doctor, or whoever is collecting that health information. They have to protect it. But it also standardizes electronic data exchange, being able to exchange that data among physicians. So if you're using a doctor in Utah and you want to get some help in Alabama, they can exchange that information. HIPAA requires organizations retain healthcare information to use information security mechanisms to protect that data. So there's a security side to HIPAA and there's a privacy side to HIPAA. From the privacy perspective, there's 5 fundamental principles. The consumer controls its medical information. Boundaries are established on the use of that information. There's accountability for the privacy of that information. There's a balance of public responsibility for the use of medical information for the greater good measured against the impact on the individual. And you must secure health information. In 2009, the American Recovery and Reinvestment Act was designed to provide a response to the economic crisis in the United States. A part of that act was the Health and Information Technology for Economic and Clinical Health Act, or HITECH, which helped again to supplement HIPAA and requires that the owners of data be notified if there are breaches of that data. And finally, in this section, the Gramm-Leach-Bliley Act of 1999 pertains to banks, security firms, and insurance companies, requires those financial institutions to disclose their privacy policies as you establish business and describe how they shared non-public personal information. There's a lot of confusion around Gramm-Leach-Bliley, and you'll just have to determine if this applies to your organization. It ensures that privacy policies are in effect in an organization that must be disclosed to the customer when you initiate that business relationship. But whether or not your firm needs to comply with Gramm-Leach-Bliley, or we usually call it just GLBA, or HIPAA or HITECH, that'll be determined by the focus of your company's business.